If you have been suffering certain problems within your marriage, you may qualify to file for VAWA and for a self-petition, which would allow you the option to possibly get your green card in the future, in addition to getting protection against deportation, a work permit, and legal status inside the United States. According to USCIS, there are several different categories under which a VAWA application may be filed. These include persons who have been married to a U.S. citizen or to a green card holder and have suffered extreme cruelty or battery by their spouse. Or also, if you are the parent of a 21-year-old U.S. citizen child and you have suffered extreme cruelty or battery by your child, or you are a child of a U.S. citizen who has committed extreme cruelty or battery against you, or if you have suffered extreme cruelty or battery by a lawful permanent resident spouse, former spouse, or parent. It does not matter whether you are a man or a woman because either can apply for protection underneath VAWA. Once you apply for VAWA, your case will take approximately 2 years or more. When your case for VAWA is approved, you will receive a work authorization underneath the category C31, and this will allow you to travel freely within the United States. And if you are eligible, you may also move on to adjustment of status for a green card. You may be eligible to apply for adjustment of status even if you entered the country illegally or if you fell out of lawful status, and you may be able to legalize your children without filing separate VAWA applications. So, in order to prove that you have suffered extreme cruelty or battery, what qualifies and what sort of evidence do you need? The law underneath VAWA is made to be purposefully flexible because the government knows that when you have suffered either physical or emotional abuse, it can be very difficult to prove that you have gone through these situations. So the standard of evidence is any credible evidence. So while the most common perception of abuse involves any sort of physical violence, the less well-known and the less well-understood qualifying abuse is extreme cruelty, otherwise more commonly understood as emotional abuse. USCIS will consider cases where there are controlling behaviors, threats to harm or deport you, forcible detention, unwanted sexual contact, and other forms of toxic behavior that is meant to control you that may constitute extreme cruelty. Proof of battery or extreme cruelty can come in many different forms, and as mentioned, the standard is any credible evidence. Some of this evidence may include police reports, court documents, psychologist evaluations, hospital records, and written witness statements from friends and families that talks about what they have witnessed you going through. You also need to prove your legal marriage and that it was legitimate and made in good faith. You need to prove that your spouse is a U.S. citizen or a green card holder, and this can be challenging to do so. Where you are not able to provide any evidence that your spouse is a U.S. citizen or a green card holder, you can provide other sorts of documentation and information to request that USCIS verify the status of your spouse. Obviously, if you can get copies of your spouse's passport, green card, U.S. birth certificate, or certificate of naturalization, this will make your process much faster and easier for the government. We help persons going through extreme cruelty and or battery put together the strongest case possible when applying for VAWA. So if you have been in an emotionally harmful or physically harmful relationship, please do give us a call so that we can set up a confidential consultation to go over your case. Once you are ready to submit the Form I-360, call the Petition for Special Immigrant along with the Form I-485 application to adjust status to USCIS. You must send all documents with your VAWA application, including a declaration affirming your eligibility, which should describe your relationship in detail along with everything that you have suffered, proof that your spouse is either a U.S. citizen or a green card holder, or proof of the other family relationship upon which your VAWA case is made, evidence of the abuse, including any sort of proof that we have just discussed, and an address where USCIS can safely send your communication. Please note that when working with my office or with any other lawyer's office, you can always elect for all letters and documents to be sent to your lawyer's office so that if you are still living with your abuser, your case can remain secure and confident. You should also include, as part of your overall package, proof of your identity, which can come in the format of a birth certificate and passport, proof of any criminal history that you have had, or proof of not having any criminal history, which you can obtain through the form of a good conduct certificate from your local police station or an FBI fingerprint check, 2 passport-style photos, and you may also elect to send your Form I-485 with a copy of your I-693 medical examination, although please note that you can later submit this at the time of your interview or if USCIS requests this through a request for evidence. And if you require any waivers in your case for certain immigration violations, such as misrepresentation or other items, then you can also send in forms I-212 or I-601 along with your I-485. You can file your I-360 together or separately from your I-485 application for adjustment of status. If you file these separately, then you must file your I-360 first, and later, when you are ready to file your I-485, you must include a copy of the receipt for your I-360. In addition, if you plan on working during this application or if you plan on traveling abroad, then along with your Form I-485, you can submit the Form I-765 for an employment authorization document and also an I-131, which is for a travel permission. Note that if you have filed your I-485 or your I-360 and you have not requested advance permission to leave the United States, then your I-485 may be considered abandoned and you may also trigger a bar to re-entering the United States. You can file all of these forms whether you are married or divorced, but please keep in mind that if you have gotten divorced from your spouse, you must file the VAWA application within 2 years of your divorce date. You must also show a connection between the divorce and the abuse that you have suffered. You may also be able to file for VAWA even if you are outside the US, as long as some of the abuse has occurred within the United States, or if your spouse is a member of the US Uniformed Services, or if your spouse was a member of the US government. Assuming that you have submitted everything properly and VAWA deems that your VAWA case is preliminarily eligible, they will issue you something called a prima facie determination within 3 months of filing your application. Note that this is not an official approval, but to me, it is a good sign that your case is on its way to an approval. Once you have received this letter, the only thing left to do is to continue to show up for an interview for the I-485 after your I-360 is approved. Rest assured that during this interview, you will not be asked any questions about the abuse that you have suffered. The questions will be focused specifically on your eligibility for a green card, which includes certain questions about your criminal history and prior immigration violations. You will also be asked for certain biographical information and information about your employment and residential history. If your VAWA case is denied, you will receive a letter of the denial explaining how to file an appeal. You can then file a notice of appeal along with a required fee at the USCIS Vermont Service Center within 33 days of receiving a denial. If your VAWA case is approved and your abuser is a US citizen, then your adjustment of status will be issued and determined around the same time. If your case is approved and your abuser is a green card holder, then you must wait to make sure that your priority date is current according to the visa bulletin before your adjustment of status application can go any further. Fortunately, even if your green card cannot be determined at the same time, upon your VAWA approval, you will receive a work authorization underneath this category and you will be authorized to remain in the US. We have helped hundreds of people successfully navigate the VAWA system, free themselves from abusers, and get legal status. If you're ready to file your petition, give us a call so that we can go over your case and whether you qualify. And if you would like to learn more about the VAWA process, I will include a link in my description below to another one of my videos so you can learn more in depth about what to expect when filing your I-360. I will also continue to release more videos about VAWA in the future, so be sure to subscribe to my channel so you can stay up to date. Click this link and I'll see you there.